Chapter 10 of the South African Law of Persons, 6th edition by Jacqueline Heaton. Under Chapter 10, we have 10.1 Introduction, 10.2 Legal Capacity, 10.3 Capacity to Act, 10.4 Capacity to Litigate, 10.5 Capacity to be held accountable for crimes and delicts, 10.6 Constitutional implications of interdiction as a prodigal. These topics are covered in pages 139 to 144. Before we proceed, thank you for listening. Please take a few seconds of your time to like this video and previous videos that you may have found helpful. And please subscribe to our channel, The Helpful Voice. 10.1 Introduction. Prodigals are persons with normal mental ability who squander their assets in an irresponsible and reckless way due to some defect in their power of judgment. See footnote 1. To protect such people and their families from their prodigal tendencies, their status can be restricted by an order of court. See footnote 2. The reason for a person's prodigality is of no real importance, but from the case law, it appears that prodigality often goes together with alcoholism, drug addiction, and/or gambling. See footnote 3. Unlike mental illness, see footnote 4, prodigality as such does not affect a person's status. It is only once the person has been declared a prodigal and has been prohibited or interdicted from managing his or her affairs that his or her capacities are restricted. Any interested party, including the prodigal personally, see footnote 5, may apply to court for an order declaring the person to be a prodigal, interdicting the person from administering his or her estate, and requesting the appointment of a curator bonus to administer the person's estate. See footnote 6. The case law reflects that it usually is a family member, particularly the prodigal's spouse, who applies for the order. See footnote 7. The application is made by way of notice of motion and supporting affidavits. The respondent must be notified of the application so that he or she may oppose it on the return day. See footnote 8. The applicant may ask that the rule nisi serve as an interim interdict restraining the respondent pending a final order for administering his or her estate. Because such an interdict has serious and far-reaching consequences for the prodigal, it will be granted only in exceptional circumstances where there is some pressing and immediate urgency. See footnote 9. So if we can remember from before, in law, nisi refers to a conditional or provincial order that becomes final unless a specified condition is met, often the representation of a reason for the order not to be made. A prodigal is not mentally incapacitated and will normally be fully able to understand the nature and implications of the application to appoint a curator bonus to administer his or her estate. Accordingly, a curator ad litem will be appointed to assist a prodigal in exceptional cases only. See footnote 10. As the rights of third parties are also affected by a declaration of prodigality, the court order must be published. See footnote 11. In Delius versus Delius, see footnote 12, it was required that the order be published in the government gazette and a local newspaper. A prodigal's status is not automatically fully reinstated when he or she abandons his or her prodigal tendencies, nor does a marriage or civil union discharge a prodigal from curatorship. See footnote 13. A prodigal regains full capacity only when he or she is discharged from curatorship by a court order. See footnote 14. 10.2 Legal capacity. The limitations on an interdicted prodigal's legal capacity relate to his or her participation in commercial dealings and handling finances. See footnote 15. For example, an interdicted prodigal is barred from being a director of a company or a trustee of an insolvent estate. See both 16 and 17. An insolvent estate is left when a deceased person's debts are greater than the total value of assets and therefore money is owed to their creditors. So I just thought quickly to add that just as a definition to what an insolvent estate is. 10.3 Capacity to act. Merely declaring someone to be a prodigal is not enough to limit the person's capacity to act. The declaration must be coupled with an order restraining the person from administering his or her estate. See footnote 18. The effect of an order that interdicts a prodigal from administering his or her estate is that the prodigal's legal position becomes analogous to that of a minor, rather than that of a mentally ill person. See footnote 19. Like a minor, an interdicted prodigal has limited capacity to act and may not independently enter into juristic acts by which he or she incurs obligations. See footnote 20. An interdicted prodigal can either enter into transactions assisted by his or her curator, or the curator can act on his or her behalf. See footnote 21. It must be remembered that a mentally ill person's incapacity to act is a result of his or her mental illness and not of the court order declaring him or her to be mentally ill, whereas an interdicted prodigal's capacity to act is restricted by the court order and not by the mental defect. See footnote 22. In Phil Mockerl, BPK versus Niemand, see footnote 23, it was said that a prodigal's capacity to act is curtailed because he or she lacks the necessary judgment to know which obligations he or she should be party to, and not because he or she cannot take part normally in the creation of an obligation. In the case of interdicted prodigals and of mentally ill persons, the purpose of the restriction on their capacity to act is protective, even though the reason for the protection differs. In the case of an interdicted prodigal, as in the case of a minor, the reason is the person's lack of judgment, or in brackets, onnoordeelkundigheid, which loosely translated to English would mean indiscriminate or indiscrimination. An interdicted prodigal's curator must honor transactions the prodigal validly concluded before being interdicted, because up till then the prodigal had full capacity to act. Please see footnote 24. If an interdicted prodigal enters into a legal transaction with a third party in disregard of the court order interdicting him or her from dealing with his or her estate, he or she may be prosecuted for contempt of court. See footnote 25. In respect of the validity of the particular transaction, the position is the same as in the case of a minor. The prodigal's curator may ratify or repudiate it. See footnote 26. If the transaction is ratified, it is binding. If repudiated, the other party must return whatever the interdicted prodigal has delivered or paid, but may hold the interdicted prodigal liable on the basis of unjustified enrichment. Please see footnotes 27 and 28. If an interdicted prodigal misrepresents himself or herself as a person having full capacity to act or as having his or her curator's consent, the question arises whether he or she can be held contractually liable on the ground of that misrepresentation. Holding an interdicted prodigal liable on the contract would defeat the object of the interdict, prohibiting him or her from dealing with his or her estate, just like holding a fraudulent minor contractually liable would defeat the object of limiting the minor's capacity to act. See footnote 29, and is therefore not supported. See footnote 30. Although there was some controversy among Roman Dutch writers on whether an interdicted prodigal may enter into a valid marriage without his or her curator's consent, see footnote 31, modern South African writers are in agreement that the curator's consent is not necessary. See footnote 32. The same should apply in respect of a civil union. A prodigal's curator cannot make a will on behalf of the prodigal, nor can the curator assist the prodigal in making one. See footnote 33. Whether the prodigal has the capacity personally to make a will is unclear. The common law position seems to be that a prodigal can execute a valid will provided that it benefits his or her descendants or otherwise deals with his or her property equitably. See footnote 34. However, as the interdict deprives the prodigal of the power to make any disposition of his or her property whatsoever, it was considered safer to obtain permission from the state to make a will. See footnote 35. To what state body application had to be made was not indicated. It seems that currently there is none in South Africa that can give the necessary consent. In ex parte F, see footnote 36, it was held that the Supreme Court, now which is the High Court, does not have the power to consent to a prodigal's making a will. The enactment of the Wills Act 7 of 1953 did not solve the problem, for the Act does not clearly indicate whether a prodigal has the capacity to make a will. Section 4 permits every person, in quotes, above the age of 16 years to make a will, unless at the time of the making of the will, that person is mentally incapable of appreciating the nature and effect of his act. As a prodigal is usually not mentally incapable of appreciating the nature and effect of his act, it seems that Section 4 empowers him or her to make a will in which he or she can, presumably like any other person who has the capacity to make a will, dispose of his or her property as he or she likes. See footnote 37. In contrast, it may be argued that Section 4 has to be interpreted in light of the common law provisions requiring the prodigal's will to benefit his or her descendants or otherwise deal equitably with his or her property. See footnote 38. The solution lies in enacting legislation which deprives an interdicted prodigal of the capacity to make a will without the consent of the court or the master of the High Court, and at the same time authorizes the court or the master to give such consent, or legislation which provides that a prodigal's estate has to devolve according to the rules of interstate succession. See footnotes 39 and 40. However, such legislation would be premised on the notion that placing limitations on a prodigal is constitutionally justifiable, which it is submitted is doubtful. See footnote 41. If the arguments in Phil Morkel BPK versus Niemand, see footnote 42, are applied consistently, a will the prodigal executed before being interdicted as a prodigal remains valid because the prodigal had the required capacity to act when the will was executed. An interdicted prodigal retains parental responsibilities and rights in respect of his or her child. See footnote 43. This means, inter alia, that a prodigal can consent to his or her child's marriage without obtaining his or her curator's consent, and incongruously, apparently retains control of the child's estate. See footnote 44 and 45. So here, just to define the word incongruous or incongruously. Incongruous means not in harmony or keeping with the surroundings or other aspects of something. It's just out of place to say that the prodigal must still be in control of the child's estate. It's laughable, actually. 10.4 Capacity to litigate. In principle, an interdicted prodigal may not embark on litigation without his or her curator's consent because, through such litigation, he or she might incur liability for costs which would lead to a disposition of his or her estate and would therefore be in breach of the interdict prohibiting him or her from administering his or her estate. See footnote 46. An interdicted prodigal may, however, sue unassisted for divorce and for an order to have his or her curator dismissed or the curatorship set aside. See footnote 47. 10.5 Capacity to be held accountable for crimes and delicts. Prodigality and an order interdicting a prodigal from administering his or her estate do not affect the prodigal's capacity to be held accountable for crimes and delicts he or she commits. See footnote 48. 10.6 Constitutional implications of interdiction as a prodigal. It is submitted that the limitations placed on interdicted prodigals are unconstitutional. The interdict preventing the prodigal from administering his or her estate infringes his or her rights to dignity and privacy. See footnotes 49 and 50. It might be argued that the infringement is reasonable and justifiable in the case of a prodigal with dependents to support, as a society is justified in requiring a person who has dependents to conform to socially acceptable spending patterns lest his dependents become a charge upon society through his profligacy. See footnote 51. So quickly, just to define the word profligacy, it basically means excessive or reckless extravagance or wastefulness in the use of resources. Profligacy. However, Distinguishing between prodigals with dependents and those without dependents falls foul of the right to equality before the law and equal protection and benefit of the law. See footnote 52. It is submitted that the duty of support is an insufficient justification for the infringement of the prodigal's constitutional rights, and that the limitations placed on all prodigals are unconstitutional. See footnote 53. And with that is the end of our chapter 10. Our next chapter, chapter 11, focuses on insolvency. That will be our next topic. Hey there, thank you for listening. If this was helpful to you, please take a minute to subscribe, like, comment, and share.